Hi, I'm Nicholas Maruchek. I'm a lawyer at MKI Legal, and today I'm going to share with you 3 common breaches of the employment law that businesses make in Australia. The first mistake involves having someone do unpaid work experience. Now, work experience has many benefits. It allows the participant to gain real industry experience, which means that person has a better chance of finding a job when they finish their studies. So, the important thing to remember is that if a person is undertaking unpaid work, there generally won't be any problems if that unpaid work is part of a formal work experience arrangement through an educational or training institution. For example, if a student is studying something like medicine, occupational therapy, or physio, and that student needs to work in a hospital or clinic environment to pass a class or to get an accreditation, there generally won't be any problems with that person undertaking any form of unpaid work. Problems do arise if someone is working without pay outside of a formal education curriculum. If it's outside a formal education curriculum, you need to be careful not to establish an employment relationship. If an employment relationship is established and the person is not being paid to do the work, then the business will be in massive breach of the Fair Work Act. Now, that breach will result most likely in a civil penalty being imposed against the business and the worker being paid back their minimum entitlements. So it's very important that businesses get this right. If someone is doing unpaid work outside of a formal education curriculum, then to avoid establishing an employment relationship, the work must generally be done for the purpose of providing that person with learning and experience. This generally means that person must undertake observational work rather than productive work. If the work that the person is doing is not learning, but work that adds value for the business, such as secretarial duties, stacking shelves, or answering phones, then that may be a breach of the law because an employment relationship is being established. A simple question that a business can ask when someone is doing unpaid work is to ask whether that work is normally done by a paid employee. If it is, then that work is likely not learning and experience type of work, but productive work. Second mistake relates to a failure to consult before introducing a major workplace change. Now, if the business has employees who are covered by a modern award, then chances are there is an obligation in the modern award for the business to consult with employees before a major workplace change is introduced. When a modern award applies, businesses are generally pretty good in complying with their consultation requirements before they make any employees redundant. However, there are generally obligations to consult when other workplace changes are introduced, such as changes relating to job structure, work availability, hours of work, promotion, training, and relocations. Businesses often forget to consult when these other types of changes are introduced. So it's important for both workers and businesses to read the appropriate modern award that applies to them. The final mistake relates to a failure for businesses to provide the worker with a Fair Work information statement. Now, the Fair Work Act requires businesses to provide a worker a copy of the Fair Work information statement before or as soon as practical after the employee starts work. The statement contains important information about the worker's rights. Now, you can get a copy of the statement at the Fair Work Ombudsman website or a link below in the description. Guys, please subscribe for regular updates and information on employment law that applies in Australia.